Good morning. I'm Peter Bartnick, a board-certified civil trial attorney practicing law in Connecticut. Today I'm going to do a short video about constructive discharge. And generally, a constructive discharge claim is a claim where an employee makes that they were fired from their job, but they weren't affirmatively fired by the employer. In other words, the employer didn't say, "You're fired, go home." Instead, the employer made the workplace conditions so intolerable that the employee just had to quit the job. Normally, when an employee quits the job, it makes it virtually impossible to bring any sort of a good claim. A constructive discharge is a unique situation where an employee actually resigns their position and can still bring a claim. So in this particular case, was recently decided, and it was interesting, so that's why I wanted to bring it to your attention. The appellate court in Connecticut decided that the plaintiff's complaint did not state a proper cause of action because the allegations in the complaint did not say that the employer intended to create a situation that was so intolerable that the employee had to resign. In that case, the plaintiff claimed that the standard should be different, that the standard should be that the only thing they need to prove is that the employer created working conditions that happen to be so intolerable. So there's a distinction. So what the appellate court said was that the plaintiff has to prove that the employer had the subjective intent of making the conditions so intolerable to force the employee to resign. And so that would be different from a situation where the employer didn't necessarily have the intent to make the conditions so intolerable to force the employee to resign, but instead they simply they intended to create working conditions, of course, but their intent may not have been to create conditions that were so intolerable to force someone to resign. So based on this rule, the rule is that right now in Connecticut, if you want to make a constructive discharge claim, you need to prove that the employer, number one, the employer had the subjective intent to make conditions so intolerable that they were intended to force the employee to resign. The second element is that a reasonable person in the shoes of the employee would believe that these conditions were so intolerable and that any reasonable person would be forced to resign. So those are the two elements for a constructive discharge claim. And this case is the case of Karagozian versus U.S. Optical, just decided. And so this would impact anybody considering a constructive discharge claim. I hope this information is useful. Have a good afternoon. Bye-bye.